This background leads to the famous Youngstown Sheet and Tube Company v. Sawyer case. The Youngstown framework, which as we'll see derives from a concurrence written by Justice Jackson, remains the lens through which the courts view the scope of the president's inherent powers. The litigation in Youngstown resulted from an executive order issued by President Harry S. Truman in 1952 during the Korean War. Truman was vice president during Franklin Roosevelt's fourth presidential term. Roosevelt died of a cerebral hemorrhage 11 weeks into his fourth term, leaving Truman as president at the conclusion of World War II. Truman ordered the atomic bomb attacks against Hiroshima and Nagasaki in 1945 that ended the war against Japan. The end of World War II saw the rise of the Cold War between the United States and the Soviet Union. Japan had annexed Korea in 1910 after the Russo-Japanese War. At the conclusion of World War II, the formerly allied powers of the US and the Soviet Union could not agree on what to do with Korea. And by 1948, Korea was divided into two competing nations, the Communist Democratic People's Republic of Korea, or DPRK, in North Korea, backed by the Chinese and the Soviets, and the Republic of South Korea, backed by the United States. Meanwhile, the Chinese Civil War, which included fighting before and after World War II, concluded in 1949 with the establishment of the Communist People's Republic of China, the PRC. American and European leaders feared that, backed by the Soviets and the Chinese, communism would spread throughout Southeast Asia, heightening what they perceived as a new global threat to Western democracy. One of the reasons the U.S. succeeded in World War II was the mobilization of the new industrial economy for the war effort. Basic materials for producing ships, planes, weapons, and ordnance, such as steel, were dedicated almost entirely to the war effort through direct measures such as rationing and price controls. When the economy demobilized after World War II concluded, there were widespread disruptions, including strikes and other labor conflicts, throughout the U.S. industrial base. For example, in 1946, Truman issued an order for federal control of the railroads to curtail a threatened national rail strike. When the railway union struck anyway, the national rail system shut down until the strike was settled.
Frantic travelers jam the stations of the nation as the long-awaited railroad strike enters its first hours, and tickets are no longer to be had. Weeks of negotiation prove fruitless, cutting off shipments of vital supplies and leaving thousands stranded in every part of the country. In Washington, storm center of the labor controversy, Colonel Monroe Johnson, Defense Transportation Chief, takes over the railroads with his group of assistants. While at the White House, A.F. Whitney and Alvin Lee Johnston arrive for last-minute negotiations with the president's mediators. Railroad management representatives also seek to avert the strike, which costs the nation's carriers $25 million daily in lost revenue. The wheels of the country's railroads grind slowly to a halt as 250,000 trainmen and engineers walk off the job. The nation's main arteries of transportation are cut, and America's march toward reconversion suffers another crippling setback.
The coal and steel industries likewise experienced massive labor unrest. In 1947, Congress passed the Taft-Hartley Act, an anti-labor measure. Although Truman had difficult relationships with the unions, he vetoed the Taft-Hartley Act, but Congress passed it into law over his veto. The Taft-Hartley Act stated that if the president finds a strike or impending work stoppage threatens national health and safety, the president may 1. Obtain a report from a board of inquiry, 2. Use that report as a basis for a federal court action seeking to enjoin the strike, 3. In that action, the court may issue an injunction lasting 80 days, during which the parties must submit to mediation, and 4. Take further legal action if the mediation fails. The DPRK invaded South Korea on June 25, 1950. The United Nations Security Council sent security forces to South Korea to help repel the invasion, which were almost entirely provisioned by the United States. The result was an undeclared war in which U.S. military forces fought against Chinese-backed DPRK forces. Truman wanted to ensure the availability of materiel such as steel in the event the conflict continued to ramp up. Instead of direct price controls, he created a wage stabilization board to limit worker wage increases in key industries, with the rationale that keeping wages down ultimately would keep prices down. The United Steelworkers of America union saw this as a ruse designed to hurt the unions and threatened a national steelworkers strike. Let's pause to notice a few things here. It was a time of economic instability. The economic instability was seriously affecting industrial labor workers, and there was a growing military crisis. These are the kinds of circumstances that require some kind of executive action, and the kind of executive action that results often leads to serious constitutional questions about executive power. Truman had at least two statutory options available to him. He could have invoked the Taft-Hartley Act to initiate the process that could have led to a court injunction suspending the strike pending mediation. He also could have invoked Section 18 of the Selective Service Act of 1948, which created an expedited procurement process whenever the President, after consultation with and receiving advice from the National Security Resources Board, determines that it is in the best interest of national security for the government to obtain prompt delivery of any articles or materials, the procurement of which has been authorized by the Congress exclusively for the use of the armed forces of the United States. But Truman wanted to move more quickly than either of these procedures provided. He therefore chose to invoke his inherent executive powers and to issue an executive order not tied to any statutory framework. Executive Order 10340 stated that the Secretary of Commerce is hereby authorized and directed to take possession of all such of the plants, facilities, and other property of the companies named in the list attached hereto or any part thereof as he may deem necessary in the interest of national defense, and to operate or to arrange for the operation thereof, and to do all things necessary for or incidental to such operation. In other words, the federal government took over the steel mills. The steel companies immediately filed a lawsuit seeking an injunction against enforcement of Executive Order 10340. A motion for a temporary restraining order was heard the day after the executive order was issued. That motion was denied, but shortly thereafter, the trial court issued a preliminary injunction against the executive order. On an emergency motion, the Court of Appeals for the D.C. Circuit stayed the preliminary injunction pending review of a certiorari petition by the Supreme Court. This brought the union and the steel companies to the negotiating table, but the Supreme Court quickly granted the petition for certiorari and issued a stay of the Court of Appeals' order, which meant the steel mills would remain under government control pending Supreme Court review. Settlement talks then fell apart, and in another extraordinary move, the Supreme Court set oral argument for only 9 days after certiorari was granted. All of this background is to illustrate that this case was viewed at the time as a significant constitutional crisis. The court ultimately ruled by a 6-3 margin that President Truman's steel seizure order exceeded his executive authority. There were 5 concurring opinions, so there's no clear rule for the holding. Justice Jackson's opinion, however, has been taken up in later cases as a standard guide for reviewing assertions of inherent executive authority. Let's start by looking at Justice Black's opinion for the majority. Justice Black took a very narrow view of inherent executive power. He stated that the President's power, if any, to issue the order must stem either from an act of Congress or from the Constitution itself. He nodded toward the idea that the executive's power as Commander-in-Chief of the armed forces might also impact the civilian sphere, but argued that this must stop short of the ultimate power as such to take possession of private property in order to keep labor disputes from stopping production. Further, Justice Black argued the founders of this nation entrusted the lawmaking power to the Congress alone in both good and bad times. In his concurring opinion, Justice Frankfurter argued that Justice Black's understanding was overly formalistic and ignored the lessons of history. Justice Frankfurter suggested that if there were evidence of a systematic, unbroken executive practice long pursued to the knowledge of Congress and never before questioned, the court should ordinarily uphold that practice as a valid exercise of inherent executive powers. In the particular case of seizing property during a labor dispute, however, Justice Frankfurter saw no such evidence and therefore agreed that President Truman's order went too far. This leads to Justice Jackson's famous concurrence, which in some ways marks a position between Justices Black and Frankfurter. Justice Jackson thought that the historical developments are particularly important when assessing inherent executive powers. Just what our forefathers did envision, or would have envisioned had they foreseen modern conditions, Justice Jackson suggested, must be divined from materials almost as enigmatic as the dreams Joseph was called upon to interpret for Pharaoh. For Justice Jackson, this meant that presidential powers are not fixed but fluctuate, depending upon their disjunction or conjunction with those of Congress. With these background principles, Justice Jackson suggested 3 zones of executive power. First, when the President acts pursuant to an express or implied authorization of Congress, his authority is at its maximum. Within this zone, if the president's action is held unconstitutional, it is because the federal government as a whole lacks power. Second is a zone of twilight, when the president acts in absence of either a congressional grant or denial of authority. Here, the validity of the president's action depends on the imperatives of events and contemporary imponderables rather than on abstract theories of law. Third is a zone in which the president's power is at its lowest ebb, when the president takes measures incompatible with the express or implied will of Congress. Here, the president must rely on his own constitutional powers minus any constitutional powers of Congress over the matter. Justice Jackson placed President Truman's steel seizure order into the third zone. In developing and applying this framework, Justice Jackson rejected the government's argument that the president's actions were justified by a general emergency or war power. The formula necessity knows no law, he said, was dangerous, and the president's ability to influence Congress through the bully pulpit of the office and through his or her role as head of one of the parties in a two-party system ordinarily should suffice as leverage. As Justice Jackson noted, with all its defects, delays, and inconveniences, men have discovered no technique for long-preserving free government except that the executive be under the law, and that the law be made by parliamentary deliberations. Here, Congress had already made specific provisions for circumstances like the steel strike in the Taft-Hartley Act and the Selective Service Act. The provisions from Congress constrained the president's range of choices, and if the president did not like those constraints, he was free to seek a change in the law from Congress. Further, Justice Jackson concluded, the Commander-in-Chief power in Article 2, Clause 2 did not extend to a power to seize privately owned steel companies under these circumstances. No doctrine that the court could promulgate would seem to me more sinister and alarming, Justice Jackson suggested, than that a president whose conduct of foreign affairs is so largely uncontrolled and often even is unknown can vastly enlarge his mastery over the internal affairs of the country by his own commitment of the nation's armed forces to some foreign venture. Indeed, he noted, the president does not have a constitutional monopoly on war powers, since under Article 1, Section 8, the Congress, not the president, has the power to declare war. Justice Vinson's dissent, joined by Justices Reed and Minton, reflected the view that strong executive action is necessary and constitutionally justified in times of war and crisis. For Justice Vinson, executive inaction in this situation, courting national disaster, is foreign to the concept of energy and initiative in the executive as created by the Founding Fathers. Although this view did not carry the day in the steel seizure case, we will see it appear again in the War on Terror under George W. Bush administration and in current debates about immigration policy and other issues under the Trump administration. It's a view that relates to the broader question tangentially discussed but not really decided in Youngstown. Does the executive possess general inherent powers in addition to those specifically enumerated in Article 2?